Mr. Gerstein. Thank you.
I'd like to start off with the whole question about the gun legislation in Canada. Much has been made, not so much an oral argument, but rather a written argument about the necessity for gun control legislation in Canada and who could gainsay that. The question, however, about the fact about whether it is a coherent and rational structure which bears significant analysis in my submission is somewhat different. And I don't want to spend very much time on this, but I just want to draw your attention to a couple of places where I say that this legislation is less coherent and less reasonable than it may seem. One of the factors which has been raised by my friends, for example, is that the scheme of the legislation as a whole and the scheme of legislation as encompassed in Section 95 both deters and denounces. One of the things which I will develop throughout the course of my submission is that in my submission, Section 95 itself does not deter and does not denounce. Now, one of the things I would like to raise is, for example, no one would say, of course they could not, that firearms are not inherently dangerous, that perhaps we live in a better society than the United States because we regulate them strictly and the like. But I wish to bring forward, while we consider this whole barbarians at the gate idea about firearms and we need to protect ourselves, that, for example, that while guns as a percentage of crime is going up, clearly violent crime and specifically homicides are going down. As a matter of fact, I've included a tab 1. I won't take you
Isn't this for Parliament to decide, though, this debate?
It is. I raise it only because it is so often during the course of these discussions a staple of the Crown submission that we have this overwhelming problem which we need to regulate severely. I just wish to bring a couple of things to the Court's attention. The first of them is that, of course, murder statistics are going down, and I've reproduced at tab 1 of my compendium the fact that in 2011, Jurastat said that the rate of firearms homicide was at the lowest rate in the last 50 years. So in my submission, the whole question about what exactly do we need to do to combat this pressing problem also must be borne in that particular light. The second thing is that during the course of the time while these initiatives were being brought forward to increase the mandatory minimums in Section 95 is exactly the same time that, somewhat paradoxically, the same government was reducing the control that we have over long guns and other forms of firearms by, for example, destroying the long gun registry, actually eliminating information that we had on those particular matters. Now, I really don't want to go too far into these matters. I appreciate very much, Chief Justice McLaughlin, your comment, but I couldn't resist, to a certain extent, bringing forward some notes to bring forward into this, because there very much is, in the Crown submissions, this whole idea that significant laws are necessary because of this avalanche of problem which is before you. Now, one of the things that I'd like to bring forward, which has already been touched on by some of you here today, is this whole question about harsher penalties do not have a deterrent effect. Now, this is a matter which was the subject of evidence being called in the Noor matter. It may have escaped your attention. It doesn't form any significant part of the record which is before you, although we put it in our compendium. But there were days' worth of expert evidence called on this very topic. Professor Dube, who was at that time the chair of the Department of Criminology at the University of Toronto, and a couple of experts who were also called by the Crown on this particular matter, speaking specifically to the question about whether or not increased harsh penalties actually produce deterrence. And I would rely very much on the conclusions of Professor Dube and the many articles which I have put forward, some of them in the materials which are before you in my authorities, to the effect that they do not. The most telling and perhaps memorable account of this comes by Professor Dube, who said it's a bit like searching for Sasquatch, that eventually you have to look over every hill, and you could say to yourself, maybe there's a hill where I haven't found it, but eventually you have to say, we've been looking for it for 20 years, we just got to come to the conclusion that it doesn't exist. And that's very much the conclusion that Professor Dube brought forward. And that is all the more emphasized by the extraordinary amount of study which has been done on this particular question. Studies, for example, in California under the three strikes and you're out law, where overwhelming peer-reviewed macro studies found that there was no decline that could all be traced to this particular matter.
Does the efficacy of a sentence figure into the gross disproportionality analysis?
It may. It fits in on a couple of different questions. Clearly, the question about penological The reasons why it is that we impose sentence was specifically mentioned by Justice Gaultier in both Goulds and Morrissey as one of the factors which needed to be taken into account. Clearly, obviously, it would have effect on Section 1, although I would be surprised, candidly, if that was really the battle place where we were actually going to be fighting all of these matters. The question always has to be raised during the course of any constitutional litigation: at what cost do we gain such a measure? At what is the price for the candle that we bring forward? But moving beyond the whole question about whether or not mandatory minimums, and to a certain extent I brought that up as much as I did because of Justice Bella's comments, but to a certain extent, Section 95 really reduces much further the possibility of deterrence because of the nature of the section itself. The whole rationale that is posited by people about why it is that a mandatory minimum sentence deters is because they say, let the hue and cry go out to the nation. If you touch this thing, you'll go to jail for 3 years. And in fact, we deem a knowledge in Canadians of the fact that they know the law, so they must know this, sometimes in the face of all evidence. But on the other hand, we cannot deem to Canadians that they will know the result of Crown election. Prior to the advancement of this particular 3-year mandatory minimum, you could get an absolute discharge all the way up to 10 years. After the mandatory minimum, you could get an absolute discharge all the way up to 10 years. There is no way that your ordinary Canadian could decide on the result of Crown elections. That you can't deem that. You can't say that they will know what's going to happen. So that your average Canadian, when they're considering nominally whether or not to commit a certain crime and considering the state of the law as they must know it, will not know what the potential penalty would be if they were to commit this crime. It would be completely obscure to them. They cannot know. So
they have a pretty good idea if they didn't have a license and no authorization and no registration certificate, I would have thought, in most cases. When they're not doing anything for a legitimate purpose, I would have thought they'd have a pretty good idea.
That they would be receiving a significant sentence?
Yes.
I don't disagree with you, but the question here is the imposition of the mandatory minimum sentence of incarceration of 3 years. This Court and all courts of appeal, the Ontario Court of Appeal and all other courts of appeal, have been absolutely clear that gun violence is intolerable and must be strictly dealt with. There is no question of that, and nobody is suggesting anything to the contrary. The question here is, do we embark on this Procrustean bed of putting mandatory minimum sentences in order to achieve the virtue of deterrence? And my submission that the increase in the mandatory minimum sentence in this case cannot inform your average Canadian about the fact of the likely result of what is going to happen to him if he is found guilty of this, beyond the fact that generally he may be said to believe that he would be strictly dealt with. The ambit of this section has not changed. If we consider this, to use a rather flip example, if we consider Section 95 as a dinner roll, we've just replaced it with exactly the same size of donut, right? There is no difference. The minimum remains and the top end remains. The only thing that is changed by this is that we have taken a chunk out of the middle of the sentencing range. And in my submission specifically, and this point was specifically raised with the Crown's main expert on this point, and he specifically said that in those circumstances there could be no deterrent effect by the raising of this. So that the denunciatory aspect, it is still, as it always was, that you can go all the way down to the bottom and all the way to the top. Section 95 does not denounce. It allows for a huge continuum of what the possible penalties are, and it does not deter. And don't take my word for it. The Crown's very experts said exactly the same thing.
What was the purpose of the former government, not this government, the former government introducing this minimum to begin with?
Well, I'd
like you to answer that, please, and also, if you don't mind, while you're there, tell me the difference between Justice Doherty's hypothetical now as opposed to then, and whether then he gets a year, whether that would be grossly disproportionate.
In my submission, it's always a little opaque to gaze into the question about parliamentary intention. But in my submission, clearly what they were trying to do is very much what the government of the day today is trying to do, and that is to say, to send out a deterrent message to other people I mean, that's the nicest way that I can put it. It could also be said that we could almost take judicial notice of the fact that governments try to do things for a series of reasons, ideological and otherwise, which please various different constituencies and the like. But at a minimum, to use the various different words that were used during the speeches, is that they were trying to denounce and deter unlawful conduct by some. I point out, and this has been raised before, that the denouncing and the deterring of the unlawful conduct is at the high end of the spectrum of this, and the difficulty, as Justice Doherty found, is that it covered a wide swatch of things, very much as it did in Smith. But to answer the second portion of your question, Justice Moldaver, in my submission, it would still be grossly disproportionate. That if a person is still supposed to be getting an absolute discharge for something, but instead receives a year in prison, in my submission, that is still grossly disproportionate. Now, I would also say that the other difficulty about the question about mandatory minimum sentences, and I think that we need to a certain extent, as part of this conversation, say that not all mandatory minimum sentences apply in the same way, right? The mandatory minimum sentence of 7 days is not the mandatory minimum sentence of 3 years, and is not the mandatory minimum sentence in Smith of 7 years. I mean, they're not the same thing. We can speak about them abstractly, but realistically, constructing an hypothesis about a doomsday scenario and a mandatory minimum, we also have to look at the nature of the sanction which is actually seen to be put forward. The larger the sentence that is imposed, the more it can bring forward potentially a grossly disproportionate sentence in my submission. The difficulty is about a grossly disproportionate sentence is if you have the top end of 7 days, it's much more difficult to come to that. And I'm tempted, I will take you to Goult's later on, but some of the analyses which flowed in my submission from the various different cases prior to this case here today are tied up, as they always are tied up, in the nature of the facts which they bring forward. Now, in my submission, the Ontario Court of Appeal was right to find that Section 95 breached Section 12 by way of a reasonable hypothetical. And you will notice, please, the fact that this is an ambit, this is a section which has an incredibly wide ambit. Don't take my word for it. That's exactly what Parliament seems to suggest by suggesting everything from 10 years in prison to an absolute discharge during the course of it.
Sorry to interrupt you again.
Sure.
I apologize. I really do, but I have to get this clear in my head. I heard your answer saying that the former regime would also be unconstitutional.
Yes.
And so my question is, how long was that regime outstanding? And was there ever a successful constitutional attack on it based on the kind of hypothetical that Justice Doherty has posed?
No, there was never a successful constitutional challenge on it. I don't have the specific time. I could get that for you if you needed it, but it was 7 years, 5 years, something along a number of years. Let's just put it that way. There was certainly ample time for a constitutional challenge to have been brought. It's always a little opaque, frankly, when tell you something. When I looked at the constitutionality of the mandatory minimums in Newer, I was surprised that nobody had brought a constitutional challenge to it. I assumed that I would open up my computer and find that there had been and there hadn't, and I was surprised by that too. Part of it, I suppose, brings out the fact that the more that you lengthen these things, the more it seems significant and the more it's going to go forward. You see, and that brings forward another aspect, and I'm getting ahead of myself, but I can't help myself. The whole question about how it is that we decide based on reasonable hypotheticals and whether or not we should use reasonable hypotheticals, it's not always easy to bring constitutional litigation. And the more that the penalty is severe, the more likely it is that the nature of that penalty will lead to constitutional litigation. Right? If you're only facing a one-year problem, you have problems, frankly, speaking from an absolute way. It takes a while, for example, to get up to Superior Court. You've probably got enough pretrial custody in. You may very well not get legal aid to fund your appeal if you want to go there because it's already moot. There are a whole series of reasons why it is that matters don't progress through the courts. But let me go back to a certain extent about the width of this provision, because it is very wide and it is very much like Smith, and it is to be distinguished in my submission from a number of the other cases that are going forward here. Now, the Attorney General for Canada in their factum said that there are no small-time offenders under Section 95. In my submission, that is not and cannot be correct, given the nature of the statutory scheme itself. The offence in Smith, although it was a very serious offence for the purpose of Smith, and it's worth remembering that Smith didn't actually meet the test for the reasonable hypothetical himself as a cocaine importer, but they used that particular test because they found it was a broad and had wide amplitude. Section 95 is exactly such an offence. It goes from people who are monstrously criminally culpable to people whose activities, in my submission, create almost no harm. And the Attorney Generals who have before me would certainly say, and have said in their factums, that there are no such people and that there is always harm. If that is so, I ask rhetorically, how is it that these people who have created such obvious harm, Parliament says, are entitled to an absolute discharge? The only people who are entitled to an absolute discharge are persons, in my submission, who have created no more harm than one could imagine. Very much like the person who comes into Canada with a joint in his pocket has presumably done some nominal harm to Canada by so doing, but not to any measurable degree. This is exactly that same sort of statute. So that when
another aspect of this, though, is that the criminal law often serves a preventive function, and
yes.
what's prohibited is bigger than the core of the harm that's really being addressed, and I guess the impaired driving is perhaps a good example of that, where with the presumptions and so on, a lot of conduct that seems quite a long way from actually driving while impaired ends up getting prohibited and for that matter, subject to minimum sentences potentially. So I guess where does the preventive aspect of this fit into the grossly disproportional analysis?
The question about the grossly disproportionate analysis, I suppose, is, in my submission, doesn't so much deal with that. The reason why, in my submission, something is grossly disproportionate is because it is far in excess. It is a sort of a horrible sentence given the degree of culpability. The reason why it is that you enact a statute, in my submission, like this one, and I agree that it is largely preventive, but the question of the gross disproportionality goes at the other end, allowing for the moment that it's a good idea to prohibit these things to prevent future harm, which in my submission is not questioned. The question is, what effect does it have? What, by the sanction which you ascribe to this particular motivation, what is the effect of that sanction, and how does that go to it? I mean, in Goultz and Morrissey, much has been made about those two particular tests, and I've included them in my compendium at those parts, but what is important in my submission to remember during the course of both of them is in both cases, Justice Gaultier was at some pains to recall that the example in Smith was correct. In Goultz, he said that the reason for that being correct was because it could easily be imagined and because it cast such a wide net. And he was at some pains in Goultz to say that the wide net was not duplicated in this particular section. That in the example that he had in Goultz, it was not a wide ambit. There were a whole series of things that had to be done, and that there were no small offenders, a phrase he specifically used. Whereas in the case at Barr, of course, there are small offenders. In Section 95, there are small offenders, and Parliament said so. Specifically as well, in Morrissey, the same thing occurred. He said again that the considerations which went into the one joint reasonable hypothetical were reasonable in that case for a lot of those reasons. I mean, in Morrissey, of course, the offense which was brought forward, there is never an easy or a non-aggravated form of causing the death of another human being, right? Somebody has to pay the weregild, the death price, and that's the nature of that particular thing. It's a very different circumstance in my submission than the circumstance at Barr, where Parliament has mandated the fact that there are small-time offenders and that it does cast an exceptionally broad net.
Mr. Derstein, I'm not quite sure that I'm following your argument about it casting a wide net. As I read Section 84 about prohibited and restricted weapons, this seems to be a fairly finely crafted provision to which Section 95 applies, and it includes certain kinds of weapons. Looks like it's sawed-off shotguns and automatic revolvers and things like that that are unregistered and unlicensed. And it excludes antique firearms, weapons used for other certain purposes, and things like that. So it looks as if Parliament has taken a pretty fine look at this. It just hasn't thrown in every kind of weapon that exists. So I'm not quite sure that I'm following about this wide ambit that you're talking about.
I'm happy to be more clear, Justice Rothstein. What I meant about that is that the purpose and the effect and the rationale behind this law, and it's been excerpted in many of the written submissions which are before you, was to counter and combat the scourge of guns being used in criminal ways, right? That's the reason why it came forward. But into that net, and that's what Justice Doherty's point was, falls the regulatory. And falls the person whose criminal activity is enormously less than the criminal activity which fundamentally this legislation seeks to deter. And so that's why in my submission it can be said to cast such a wide net. Any statute in my submission that has everything from an absolute discharge to 10 years in prison is a matter which it casts a wide net. In my submission, the Parliament's intention about that could not be made more clear by its very enunciation of the sentence which it suggests is appropriate.
Well, I guess if somebody has a sawed-off shotgun for innocent purposes, by your reckoning, that's subject to this wide net. And
it is, and I mean,
I wonder whether that's realistic. If we're going to talk about realistic hypotheticals, somebody has a sawed-off shotgun, unregistered, unlicensed. I'm not sure that it's so obvious to me that you can find a reasonable hypothetical that would exist that wouldn't be culpable.
That would not be culpable? Oh, it would clearly be culpable. I mean, any of the things that get enmeshed in this would be culpable. The question is whether they deserve 3 years in the penitentiary. Bear in mind, please, that during the course of the analysis of this section, that although it is predicated on the question of danger, danger is not part of the elements of the offense of this particular matter. Parliament could have said in a dangerous way or for dangerous reasons or putting people at risk or things of that nature, but it did not. There's no element of danger in this. There's no element of, for example, that the possession is other than transitory or other than quick. A person can literally handle a firearm for 45 seconds and be guilty of this particular offense. The Smickle facts, for example, although Justice Doherty found no favor with this argument, I'll try it out on this court. The question about somebody walking into a room, for example, and I'm changing the facts in Smickle a touch, but bear with me. Somebody walking into a particular room which belongs to a cousin or what have you who's a bad man, which is very much the facts in Smickle. He walks over there and says, oh, look, here's this firearm down there, and there are a couple of bullets, but it's unloaded. In Smickle it was loaded. That's the part that I'm changing. You walk in there and you say, hey, how cool is this? And you pick it up and you take a little selfie of yourself, and then you're interrupted 30 seconds later. Right? That's the nature and the extent of the criminal culpability which leads to that particular finding. In my submission, I mean, I'll address this head on, that particular question, that particular offender would be grossly disproportionate to sentence him to 3 years in the penitentiary. If that gun was unloaded, the fact that there are bullets that are rattling around on the table in front of him means that the sanction which should be applied to the person who left those things around is significant. But to the poor young dupe who picks it up and poses for it for a second before being interrupted, in my submission, he has not actually put anybody at risk. Bullets are not like amoeba that float into the gun and all of a sudden can discharge automatically. The question here is if he postures with this particular gun for a moment, which of us as young persons, perhaps not you guys, which of us as young persons has not done something foolish briefly in our lives, right? Did we all deserve to go to the penitentiary for 3 years for? In my submission, it's grossly disproportionate even on that particular basis. So, I mean, and there's an example about a sort of a young urban fellow actually holding it, and it's not a sort of a rural cottage owner, so didn't find favor elsewhere. But in my submission, that would be a reasonable hypothetical that you could find and is closer to many of the reported cases in my submission. Although I have to pause for a moment and say that you should be very, very careful about the use of the charts. I say this very respectfully to my friends from the Attorney General for Canada, about using charts about reported decisions as some sort of empirical survey from which to conclude anything. The nature and the effect, these were not statistics which were put forward as part of any prior litigation. There's been no analysis of them. How it is that they came forward is still somewhat opaque. The question about whether or not they are accurate, whether or not they properly capture a broad range of what actually exists in Canada has not been tested, and my submission has not been tested at all, and you should be very cautious before you should use them at all. Now,
you've been arguing that cases like Smithell and so on just show that this law can have grossly disproportionate effects. Why do you need the reasonable hypothetical?
The question about the reasonable hypothetical, and it's a useful point to get to right now. The question about the reasonable hypothetical is that to a certain extent, and this is an answer to what you said earlier, Chief Justice, is that to a certain extent, when one comes to constitutional litigation, where one's defense against the state is predicated on the fact of the unconstitutionality of a given law, the character of that litigation changes. It no longer fundamentally is the fact about only applying to you in my submission. To a very large measure, it applies to the question about the proper constitutionality of that particular section. And that, to a certain extent, is the question about Big M. Now, we could argue it based on the fact that that's an established principle, but you can also argue it based on a series of other principles. You can argue it based on access to justice, for example. It's not everybody who's going to be able to wield the sword of constitutional litigation. Many cannot. I included that case about Morrison, about that poor hairdresser woman who didn't want to bear the weight of constitutional litigation, so resigned herself to a 3-year sentence, where Justice Cole in the provincial court seemed very unhappy about the idea of wielding it. One of the reasons why it is that we do reasonable hypotheticals in my submission has to relate to a question of access to justice. But the other thing is, and I appreciate the question that by and large the common law tradition, generally in fact, the common law tradition is to decide things based on established cases. But to a certain extent, we have to move outside of that in certain cases for the reasons that we've put forward.
Well, my question is a little narrower. Doesn't it suffice to point to cases like Smithell? I don't deny the Big M principle, of course, or the propriety when it's necessary, and it may be in certain situations. But in a case like this, if you can show, just as a matter of methodology, if you can show that there are cases that might well arise where it would be unconstitutional, the Smith principle, is that not enough? And then why does a judge have to say, as a matter of law, I must construct a reasonable hypothetical with all the questions that arises? That's my question, not to go to the fundamental principle that a litigant can raise the impact of the law on other potential litigants. I accept that.
The question, if I understand your question properly, in my submission, it was most useful and easy way for the court to be able to consider the constitutionality is by dealing with other reported cases, or ideally other cases that are before them. That's the most and the best and the most ideal circumstance. But the question is that that's not always something which is easily before a given court, and that's, in my submission, why it is that we turn to the question about the reasonable hypothetical.
I'm not being very clear, but what I can see turning to a reasonable hypothetical when it's necessary, but is it necessary in every case? And is it an error in the trial judge and the Court of Appeal not to consider a reasonable hypothetical if, for example, they were satisfied on the logic of Smith? That's my question.
In my submission, if it is that the case before you is enough for you to properly consider the question about the constitutionality, then in my submission, if the error that is alleged by the applicant is amply demonstrated by the facts that are before you, then you're fine. If the error that is alleged is not before you or cannot be shown by a case which is a compendious case, then in my submission, you do need to move beyond that in order to be able to properly express the constitutional principle and to give effect to the principles that we have. It would be preferable, in my submission, to refer, for example, to other reported cases, because they have all of the advantages that we have in actually having the actual applicant's facts be there. So it's preferable to use those, but that's not necessarily so. To a certain extent, the facts which are the applicant's facts in a constitutional litigation are almost as arbitrary as a reasonable hypothetical themselves. The reasons why it is that something, that a given case, why is it that we consider the Big M case in the light of, the Big M as an applicant, right? I mean, it's a kind of an odd thing. In Edwards' books, you consider the whole question about that, but Edwards' books didn't have anybody that was going to be disgruntled by the use of a Sunday sale. The whole question about the actual nature of the factual situation and how it is that it's going to be constructed is to a certain extent arbitrary itself. So in my submission, when you speak to the question about the potential arbitrariness of using other facts, you have to bear in mind the arbitrary nature of the facts of the litigant while you are considering a constitutional principle in general.
What is the function of the change that occurred between Smith and Goltz, where we went from just saying, here's some examples, or an example of a clearly disproportionate result, grossly disproportionate result. And then in Goltz you say, no, we're going to tailor it more. We're not going to take any example. We're going to take what might reasonably happen under this law. And this concerned me in Goltz too. I dissented. You leave out the certain possible unconstitutional scenarios, and I never have understood why you would do that as a matter of methodology. Perhaps you can help me with that.
The question, again, I mean, it's a complex issue. In Goltz, in my submission, Goltz was circumscribed, was tailored in relation to its facts. It was a 7-day mandatory minimum. And so the facts which were being brought out in order to show that it was grossly disproportionate were really fairly abstruse facts, right? About the mother who was on her way with her autistic kid, and, I mean, it's really hyper-complicated facts, and that's the nature of it. So this language came out about the fact it's got to be more ordinary. But it's well to remember when we consider whether or not there has been a fundamental change, that is that change so fundamental given the fact that Justice Gontier, for the majority in Goltz and in general in Morrissey, specifically said that example had not changed. Right? And it's well to remember that in Smith, there were no reported cases which recorded this hypothetical college student with the joint in his pocket, and nobody can remember there ever having been a prosecution about it. But that was not a bar even to Justice Gontier. So that while we consider this question, has it all been very much circumscribed, it's my fundamental thesis that it may have been circumscribed in certain ways, but has not really been circumscribed in the context of statutes which are of very wide application. It was criticized of the reasonable hypotheticals that they went a long way away or that they were abstruse. But the reality of it is that there are only so many ways that you can kill a person by criminal negligence with a firearm, by unlawfully firing a firearm. You can easily come up with 2 or 3 different ways where reasonably that can happen. But the same cannot be said with a Section 95 offense. It is just as broad, if not even more broad, in my submission, than the question of the importation of narcotics, which underlay Smith.
Do you agree with the Court of Appeal that you leave out personal characteristics at the second step, the generalized inquiry?
In my submission, no. I appreciate the fact that, we can, lead ourselves down some merry path by coming up with incredibly abstruse examples, but some examples to demonstrate that the person is at the bottom end of the range, for example, would be appropriate. It's perfectly reasonable to hypothesize during the course of a mandatory minimum, for example, that the person doesn't have a criminal record. That's not abstruse or strange, and it would really change the whole thing. If you had the leader of the Hells Angels with 19 horrible convictions and, he happened to just briefly touch a gun, we might not all recoil in horror at the idea of him going off to the penitentiary. On the other hand, if it was, Gandhi who walked in there and moved it a little bit to the left, maybe we'd be a little bit upset. So that to a certain extent, the question about the individual characteristics of the litigant are important. I appreciate the idea, let's just not go crazy about this, but importing certain things. And I specifically join with some of the other persons who are to speak after me with the idea that, for example, considering the person, for example, to have no criminal record, or to be from a disadvantaged background, or to be to someone to whom the principles of Gladue exist, in my submission, all have relevancy and cogency. And, you don't have to, go too far, but having certain ideas about why a person can reasonably be at the bottom end of the range are important.
I think this is important, though, from a methodological point of view, because, as Justice Doherty pointed out, proportionality is about the relationship between two things.
Yes.
And what I guess you need to help me understand is, at the generalized inquiry level, what is on each side of that balance?
The generalized inquiry on my submission, in terms of the – sorry, I just want to understand your question.
We're talking about gross disproportionality.
Yes.
At the generalized inquiry, as between what and what?
The gross disproportionality between the actual level of the conduct and the sanction which is being levied. So that the and
level of the conduct is kind of code for a lot of different things.
It is the extent to which we can say you did wrong and the penalty which we levy against you, right? So that the extent to which you did wrong has a couple of different components. It is the actual nature of your act. What did you do? And it also has to do, to a certain extent, with who you are, right? I mean, those are the two fundamental questions that we answer on sentencing, right? I mean, what kind of a person are you? Is this, part of your character, or is it not? Is this the first-time offender? Do you have an excuse? I mean, not an excuse that would excuse it absolutely, but do you have a reason why it is you did it? Was it of a long duration? All those sorts of questions on the one hand. Your overall moral culpability, if I could put it on the one hand, and the nature of the sanction which is being levied against you in keeping with that. And I take Justice Abella's point that one of the obvious difficulties with mandatory minimum sentences is, by and large, it doesn't allow for that sort of calculus. It does at the top end. You can, in a sort of a facile way, say, well, you can consider that in 3 to 10. But by and large, what that really means is that to the extent that you don't fall easily within what one would call the ordinary sentencing regime, those matters are of no moment because you get caught up in, as I say, this Procrustean bed where you get forced up into a given area.
So is the only thing the moral culpability? Is that the only thing on the second side? Obviously, on the first side of the proportionality is the sentence. I think that's not very controversial.
Yes.
And you're saying that what has to be grossly disproportional is the sentence in relation to the moral culpability?
To the moral culpability of the offender, yes. I mean,
so the amount of danger that's created is irrelevant?
Yes, I mean, but I meant, and perhaps I shouldn't have put it that way, I mean, it is the moral culpability of the offender. If one does a worse thing, one is more morally culpable, I suppose, is the other thing. If I actually put people in danger as opposed to not.
You can kill people by pure accident.
What's that?
You can kill people by pure accident.
Sure. But, I mean, you have to be morally culpable to a lesser degree then, right? You have to be culpable to the extent that you do something negligently, which allows for it. If really you do it having no culpable state of mind at all, you're not guilty of it. The nature of your culpability need not be avertance. It can be inadvertence. But it still is a level of moral culpability. Intermixed into the question about that, I mean, I don't want to intermix into the question of that, the question about whether or not there are proper penological goals, because in my submission that really doesn't come into gross disproportionality. Gross disproportionality is measured about are we hitting this person too hard given what he did, just to use a different form of analysis.
You just continue along that, because I'm still having some difficulty understanding why you cleave to the reasonable hypothetical given the scheme. We're dealing here with statutorily imposed sentences.
Yes.
Which is different from just the fitness of sentences and looking at the principles in 718, right?
Yes.
So if it's statutorily imposed, can you tell me why an individual assessment is even helpful if it's something that is a law?
I suppose the best way I could answer that, Justice Abella, is to...
And the corollary is why a reasonable hypothetical is even assistive in that context.
In my submission, it is to demonstrate that there are persons who would be affected in a wrongful and unconstitutional way by that particular legislation. It is to illustrate why it is that level is wrong. One cannot look at my submission at a construct in the abstract. We have to see how it is that it interrelates to people before we decide on those things. So,
you can look at the principle behind a mandatory minimum and say, in principle, this interferes either substantially or not enough, the justification process that we go through with every other statute. Can't you do that without looking at the particular circumstances and assessing the constitutionality of the particular scheme or provision?
You can, and maybe that's a good segue into my Section 7 analysis, which I've only got a brief amount of time on, but let me just bring it into there, because, Your Honor, you brought forward earlier the whole question about the whether or not you could I've lost my train of thought. You brought forward earlier the question about whether mandatory minimum sentences per se might violate Section 7 during the course of an analysis. And to a certain extent, that can come forward during the course of Section 7. It's not the thrust fundamentally of this particular piece of legislation to go against all mandatory minimum sentences. And in fact, a good amount of legislative time in this particular court has been spent to a certain extent justifying them. Section 7, in a nutshell, if I can just have a second to finally get to Section 7, the question is that Section 7 cannot be seen to be some sort of pale shadow of Section 12, and that it has some other applicability. And by and large, just to reduce this to its nub, Section 7 protects against a number of other things which are not merely gross disproportionality. The gross disproportionality, which that was earlier commented on in Malmo-Levine, was in the context of should we analyze the question of the sentence under Section 7 and what would the test be. In my submission, this Court has amply found that there is a question about there should be no arbitrariness in the imposition in any way that we deprive anyone of liberty, the no arbitrariness principle. And in my submission, that has very real application to the answer to the question which you brought forward earlier, Justice Abella, and that to a certain extent the gap principle, the gap that is in Section 7, and I'll rely on my factum for the rest of this, interferes with that question of lack of arbitrariness, and that one can be extremely arbitrary while not necessarily producing a grossly disproportionate sentence, in my submission.
Can I just ask one question, Chief Justice?
Of course.
Just to follow along. We've been dealing with Section 12, and the case law is dealing with Section 12 in the context of sentencing. So we're all thinking of good idea or bad idea in connection with reasonable hypothetical in that context. But it doesn't just talk about sentencing. So I'm wondering, it's treatment or punishment, any cruel and unusual punishment. Does a reasonable hypothetical work in another context where we're dealing with treatment or punishment? Would we even be looking at a reasonable hypothetical if we were looking at, for example, solitary confinement? I'm just trying to think off the top of my head to get out of the constraint that we seem to have put ourselves in with Smith and Galtz in looking at this as a constitutional right.
Some of the circumstances which one could imagine, for example, a given practice in the southern United States, for example, there was a practice that was evolved about putting prisoners on what was called GRUE, G-R-U-E, and it was a horrible form of compressed food, and that they would be fed this for about 6 months, and it was raised as a form of punishment. And the court actually considered the question about whether or not punishing by using GRUE was okay. And that's a perfectly good example about a question of cruel and unusual punishment being raised on the particular facts of that case and not having to go any further. The difficulty is, to a certain extent, that that's a very specific example where the very facts of the litigant really illustrate the full nature of the problem. And the problem, to a certain extent, with different forms of statutes is that, and different forms of ways of breaching those statutes, is they don't so easily allow that.
But we don't need the reasonable hypothetical to figure that out.
In that case, no.
Okay, thank you.
Thank you very much.
Thank you. Mr. Ripple.
Chief Justice, Justices, I want to start by asserting why this Court should reject the proposal that the reasonable hypothetical methodology be abandoned. In my submission, it has served this Court and this country well in a number of different contexts, not just the sentencing context. Secondly, I want to demonstrate how the reasonable hypothetical test, as applied to a secondary offender, one with a second offense, offends Section 12, and that a 5-year mandatory minimum is grossly disproportionate. And then I want to deal with the Section 7 analysis, particularly as it relates to offenders who are repeat offenders. Now, the Crown's first position is that the reasonable hypothetical does not work. And first and foremost, it has to be recognized that this would be a revolutionary shift in charter standing, not only with respect to Section 12. It would really adopt an American-style case-by-case analysis, which really does not make sense in the context of this Court's jurisprudence following Ferguson, that if the Constitution is breached with respect to the sentencing of only one individual, then the entire law is struck down and it's sent back to Parliament for Parliament to fix the law. If that is the case, if it breaches one person's rights, then it breaches everyone's rights and that the law should be struck down. Why wait? If you can devise a reasonable hypothetical that strikes down the law and can send it to Parliament, there is absolutely no reason to keep a bad law on the books for longer than necessary. And there are a number of examples of this that are in paragraph 12 of our factum that exist not just in the sentencing context, obviously. Religious freedom, women's rights, privacy rights have all been expanded, not by the party directly affected, but by a litigant coming before the court with a reasonable hypothetical situation. And some of those cases have been mentioned already, Edwards' books, but also Morgenthaler, Alaba, they're in the factum. And there's simply no good reason not to do this. As Chief Justice indicated, this is somewhat more of a hybrid approach, somewhat similar to a reference. But that should be embraced. There is no reason not to adopt that approach if there is a law on the books that any reasonable person can look at it and say, one of these days, this is going to be applied unconstitutionally.
But that's my question to you, and maybe I'm right off base, I don't know, because we've never dealt with a hybrid. I keep coming back to that. Are we talking about a law itself that is unreasonable or that is unconstitutional? Or are we talking about when it's the application of this law may lead to an unconstitutional result in a particular case which might implicate other remedies? In other words, 24-1. Maybe I'm right off base, I don't know. But just the way you just said that, it dawned on me that maybe we're talking about the application of the law rather than the law itself.
I disagree, and for this reason, I'm going to embrace the question you posed earlier. Would Smith have been decided differently had it been a hybrid offense? And in my submission, it would not have, for a number of reasons. If it was a hybrid offense with a 7-year mandatory minimum and then a hybrid summary option, that would be problematic. And the reason it would be problematic is the mere potential of the 7-year mandatory minimum for the innocent person with a single joint of marijuana causes a number of adverse effects, and I want to get into a few of them with a few examples. When you have an unconstitutionally harsh sentence, all the discretion is handed over to the Crown Attorney's Office rather than the judiciary. And most of the time, we expect the Crown Attorneys to act in the great tradition of the office. But there are occasions when that becomes problematic. For example, my understanding is in Smith, when you had a 7-year mandatory minimum, if you were similar to that individual who had the single joint, the Crown Attorney would often come to you or come to your lawyer and say, well, perhaps you can plead a simple possession, perhaps you can plead to something different than the offense of importing, which attracts the 7-year mandatory minimum. And that is problematic because it gives the Crown incredible leverage with respect to extract a guilty plea, and particularly problematic if the reasonable hypothetical is factually innocent. For example, someone who picks up a jacket from their friend across the border and takes the joint unbeknownst to them across the border. So now what do you have? You have an innocent person facing a 7-year mandatory minimum. Many would feel overwhelming pressure to accept a guilty plea if it was offered to them for simple possession. If it was a hybrid offense, that wouldn't change the incredible pressure one would feel. If the 7-year is still hanging as lurking, as Justice Lemaire said, as a possibility if you don't plea, does it matter if you're offered a plea to simple possession or to a hybrid offense, a lower offense? In my submission, it would not.
Why wouldn't it? Because if the Crown in that example, as I understand the way we've been talking, would take a great risk in going by way of indictment because they would know, I would have thought it would be a laydown that by going by way of indictment and asking for 7 years for a single joint would be unconstitutional, grossly disproportionate. I just don't understand. I'm sorry you're
Well, I guess what Your Honor is saying that if there was this other option, in other words, the option of a hybrid offense, then they would never use it. They would, in essence, take a conservative approach, which gets back to trust the Crown Attorney Office never to
Oh, I'm not saying trust. I'm saying trust the judiciary. If the Crown makes the wrong call, the judges have the authority to say, you know what, this is now grossly disproportionate. I'm striking down the section, or maybe there's some other remedy depending on how we look at this. But it's not like it's like a free hand. It's not like the Crown has a free hand here. They have, I call it, the sword of Damocles hanging over their head.
The problem with that in my submission is I don't dispute that if someone went before a court and was actually charged with a single joint and got the 7 years, that would have been unconstitutional. But there is a positive benefit to striking the law down before that actual example happens, because you have this individual who, for whatever reason, the Crown decides to go by indictment. So now they are facing the 7-year mandatory minimum. They can take their chances and probably would win and have it struck down. But the point is, they could be offered a plea to a hybrid offense and take it. And then there's no review. What you have is a plea in plea court.
Let's take your example. The person has one cigarette, okay? The Crown says, you either plead guilty or I'm going to go by way of indictment. I say, thank you very much, go right ahead. Number one, if that's what you want to do. If this is designed to prevent an accused from having a trial who is really innocent, on your example, this person is innocent because he didn't know who was there. I mean, this just doesn't make any sense. The Crown would be just shooting itself in the foot by putting the accused in that position. I'd say go ahead, proceed by way of indictment, and we'll get the law struck down.
Well, part of the problem is, by admission, the single joint is a clear-cut case. But what if you have 10 joints, perhaps? Then the calculus becomes very difficult. And the fact that you have this 7-year mandatory minimum changes the whole relationship with the state once you are charged. So you have a negative law, an unconstitutional law, because as you pointed out, if it ever was litigated, it would be deemed unconstitutional. But when you get maybe closer to the line, then you're the canary in the coal mine, where you have to decide, am I going to litigate this and be true to the facts, which is I'm innocent, or if I'm facing 7 years and I could get a suspended sentence. Let's say it's not the absolute discharge levels. Perhaps you get a suspended sentence for the 10 joints. At some point, when you have a larger disconnect between the problematic behavior and the sentence you would get if you proceeded another way, it becomes very problematic. And that's even more problematic with respect to the reasonable hypotheticals of Mr. Charles, where he's then facing 5 years, which could be a pure regulatory offense, potentially, for someone even like Mr. Charles, which I'll get into. So I think it has to be recognized that keeping unconstitutional laws on the books for as long as possible does not assist. And to just say we recognize that when that case comes along, it will be deemed unconstitutional is not enough, and that's not what Smith did. Smith, again, was a cocaine trafficking case, but the court decided that this could inevitably happen, so why not strike it down and send it back to Parliament? And in my submission, that is the best way to treat laws like this, particularly ones such as the law before the court today that has an extremely wide net with respect to both, I would submit, moral culpability and, related to that, the danger that it poses.
Can I come back to the question that Justice Cromwell asked your friend? Is it your position that personal characteristics should be looked at as part of the reasonable hypothetical, let's say beyond that, first offender, no criminal record?
In my submission, they should be incorporated for a number of reasons. Because the impact of mandatory minimums is felt by the least culpable offenders, it makes sense that some of the personal characteristics that would affect the least culpable offenders should be taken into account. And Smith does this in a minor way by taking into account youthfulness and the lack of a record. So in my submission, certain characteristics, ones like those found in Section 15, ace, race, gender, and disability, are things that could be taken into account, as are the core biographical information that finds itself in a typical sentencing submission. So I would adopt a similar test to what the court has adopted for the fact pattern. The fact pattern of the reasonable hypothetical has to have characteristics that are common biographical descriptors that commonly arise in day-to-day life. So for the offense, you have to have common possibilities of the offense rising in day-to-day life, and there are certain core biographical descriptors that typically make their way into sentencing, and it only makes sense that they make their way into the reasonable hypothetical.
Can I just hold you to that for just a moment? In the same way that I have a lot of difficulty understanding what public opinion means because I don't know what the public is, who the public is, what men, women, what part of the country, rich, poor, all of that. I still have difficulty understanding how a reasonable hypothetical, a characterization developed by an individual judge, should be used as a tool to assess the constitutionality of the law. So you've talked about a constitutional law shouldn't be allowed to exist if, et cetera. But what if the reasonable hypothetical, as applied, is something that renders something we would find otherwise unconstitutional because it's not justified, constitutional because the reasonable hypothetical renders it safe? In other words, the constitutionality of a law is a legal conclusion after an analysis. So you're, in a way, presenting it as existential. It is what it is. It's but we have to figure out whether it is or it isn't constitutional. And I still don't see how a reasonable hypothetical, which, as you've finished describing it, is hard for me even to picture how poor judges are supposed to figure out what that means, how that really assists in whether or not something is constitutional.
Well, in assessing whether something is constitutional or not, there's a few ways that legislation could be potentially struck down. One is if it's prima facie unconstitutional. For example, some of the punishments that were described earlier, perhaps capital punishment, flogging, that sort of thing. You don't need a reasonable hypothetical to assist you with those. You can look at it and know it's unconstitutional. What the reasonable hypothetical assists with is, much like a reference, help strike down laws before the poor individual subject to the law is subject to it. And that's an advantage. And then you have the third level of protection with respect to the individual if they're brought before the court and raise a new set of facts. They can attempt to convince the court that the law is unconstitutional.
If you pitch the reasonable hypothetical a little bit too high, you diminish that effect, because there can be cases out there where people will suffer the unconstitutional impact. And that's my concern with the reasonable hypothetical. It seems to have got narrowed down to something that doesn't include all potential unconstitutionality, if I understand it. And so you're not doing the job you want to do as well as you should be doing it.
Well, I don't disagree. For example, both Noor and Charles had the law struck down without personal characteristics being taken into account. I am advocating that they be taken into account for even broader reasonable hypothetical. But even in the more narrow reasonable hypothetical, as conceived by Justice Doherty, the law was struck down without taking into account any personal characteristics. But as a number of the interveners state in their factum, and I would submit is the correct approach, is because mandatory minimums affect people on the lower end of the spectrum, the ones who prior to the mandatory minimums were getting a lower sentence, then it makes sense to take into account that sort of mitigating characteristics.
Doesn't that really argue for a classic constitutional analysis? Mandatory minimums prima facie, because they deprive the court of the exercise of the discretion in accordance with the sentencing principles, prima facie interfere with the constitutional right to be free from either Section 7 or Section 12. And then it becomes a question of justification. And I mean, we can all think of cases where it may be justified. So regardless of the personal circumstances of the individual, it's the constitutionality of the laws that affects everybody that you're looking at, not whether this particular individual is uniquely subjected to something cruel and unusual. Right? I mean, I'm just arguing for the sake of argument why you need to bring in something which, as the Chief Justice says, could in fact be used to render something you might think by another hypothetical is unconstitutional, constitutional. So the result in this case worked in a way that you're comfortable. The muscles did the right exercise lifting. But they might not in another case. And isn't that a bit too flimsy as foundation for assessing the constitutionality of laws which affect so many people? And the liberty interests of so many people?
Well, it's a test that we've applied for some time that has assisted. But I guess the question is, would the starting point then be that all mandatory minimums are unconstitutional, and then you have to take it case by case? I think society has decided that there are some, perhaps, offenses that deserve a short, sharp sentence, no matter who you are.
Sure. Justification. The usual process. And
I guess one example would be the Latimer case, where there weren't reasonable hypotheticals brought to bear before the court. It was only when that particular fact pattern came before the court that there was a consideration. But interestingly, under Ferguson, if that had been found to be unconstitutional, the whole scheme would fall. So if you're going to stick with Ferguson, in my submission, it does make sense to keep the reasonable hypothetical. But that doesn't necessarily end the matter, of course, because there can be a case that then comes before the court that could breach the rights. And actually, Goltz is perhaps a very good example. What happened with respect to Goltz is the Crown limited what would be viewed as unconstitutional, which left a large chunk for another day. And I think Justice McLaughlin in dissent really got it right with respect to what that impact is. If you look in British Columbia, there's a number of provincial court judges now deeming that fact pattern unconstitutional on a case-by-case basis. That's not particularly helpful. That's why a broadly understood reasonable hypothetical can be helpful. And particularly with respect to the alternative that has been posed here, the only alternative that has been proposed before this court boils down to nothing but a simple case-by-case analysis, that you actually have to wait for the right case to strike down the law. And if you were going to choose one or the other, certainly it seems that the reasonable hypothetical is the better option of the two. If there's a third, Section 7, and we did raise Section 7 in our factum as well, then that could perhaps be another route. But certainly between the two choices, one is leave a bad law in the books and wait until someone is hauled before the court to face it, versus trying to contemplate whether the law is unconstitutional. That certainly seems to be the better course.
Is there really a way of, if I look at Justice Doherty's test, the reasonable hypothetical here, or his example, is he really not looking at the characteristics of the person? If you look behind this, could you go to page 109 of the appeal book, or of the record? That's where you'll find the hypothetical. Leaving aside, I'll let you look at it, and then leaving aside the second one, because McDonald has changed that a bit, I think.
Yeah.
But you read that, I come away with the impression we're dealing with a first offender who's an otherwise honorable person, never been in trouble before, obviously a law-abiding citizen who goes out and gets an authorization and a registration certificate. I mean, you can say you're not looking at the characteristics when you create the personal characteristics. But, I mean, it seems to me if you look at this, I come away with saying, boy, that's otherwise nice person who's never been in trouble before and decent law-abiding. Can you help me with that? Because it just, you can say you're taking out the characteristics, but are you really?
Well, you're certainly including that they're law-abiding and first offender, but that has to be entirely appropriate for the reason that the focus on the mandatory minimum has to focus on those people who will be affected. And by definition, the people who will be affected are the ones who are going to receive the lower sentence, who, but for the mandatory minimum, would have received a sentence lower than the mandatory minimum. So as a starting point, for any mandatory minimum, it would only make sense to start with the mandatory minimum with someone who has no record. To contemplate a mandatory minimum with a Hell's Angel with a lengthy record simply wouldn't make any sense, because of course they're going to have a higher sentence.
But I'm not sure, because Justice Doherty, in setting out the test here at paragraph 142, says, we've got to look at it at a general level, capture the conduct that includes all the essential elements of the offense to trigger the mandatory minimum, but no more. Characteristics of the offenders, be they aggravating or not, part of the reasonable hypothetical. Well, the reasonable hypothetical that he's given with respect it does read in characteristics. You just conceded they do, and in fact, you say they must.
I guess it depends. Obviously, having no record is personal characteristic. I read the case laws when they're discussing personal characteristic. They're talking more about inherent characteristics with which you are born, and that's why we have the intervenors with respect to disadvantage, the law of Gladue, that sort of thing, is the characteristics, obviously, that Justice Doherty seems to be referring to. I don't disagree with you, Justice Moldaver, that the fact that it has no record can be defined as a personal characteristic. But that, I don't think there's any dispute that that should be taken into account. In every case, whether it be Morrissey or Goltz, all of those take into account the low end of the spectrum. Part of the point is if you kill someone, even if you have no record and are of otherwise good character, that is such an awful act that 4 years is justifiable. So in all of those cases, in my submission, personal characteristics at the level of we're going to assume that you've never been before the court before is entirely appropriate, precisely because the people who are affected are the first-time offenders, unless, again, you're dealing with a multiplier like Charles with respect to a second offense. And then you have to, in my submission, look at the least culpable of an offender who's facing the second offense. But it seems to me that it wouldn't make any sense to not hone in on those individuals who are going to be affected because prior to the legislation they would have received a lower sentence. And in order to do that, you have to take into account the personal characteristic of having no record and being an otherwise upstanding citizen. I really think what Justice Doherty meant, and it seems to be taking away the one little personal characteristic from Smith, age, I would submit that this Court should put more of those details in, and that only idiosyncratic characteristics should not go in. So, but part of the problem is, and it's been recognized, it can start to get difficult where you start to have an incredibly compelling life narrative, and that is what Justice Doherty is trying to avoid. He's trying to say, let's look at the moral culpability and danger of this offense, take it with an otherwise law-abiding citizen, and see where it gets us. And I think it's very important to note, after what this Court decided in McDonald, that the reasonable hypothetical by Justice Doherty is not the least culpable offender by any stretch of the imagination. In Noor, Justice Doherty considers, following McDonald at the Court of Appeal in Nova Scotia, that the individual at the cottage knew that the firearm wasn't supposed to be at the cottage and was not following the legislation for whatever reason. So, and in fact, the Crowns in their factums indicated, well, that really isn't that law-abiding now, is it, if you are actually doing that? McDonald has shown, and it's a real-life example. In my submission, reasonable hypotheticals are very helpful. But you don't actually need reasonable hypotheticals because McDonald is so helpful. McDonald, as you will recall, had a license in Alberta, was working in the oil fields, and then moved to Nova Scotia, thinking that he was not breaking the law. So he had no guilty mind whatsoever. And as the Court of Appeal noted in the decision that just came down, you don't have to change the facts very much. If the police responding to a noise complaint knocked on Mr. McDonald's door and saw a gun in his suitcase ready to unpack, Mr. McDonald has nothing to hide. He doesn't think he's doing anything wrong and has the bullets already put away in the closet. He is facing a mandatory 3 years in jail.
If the Crown goes by way of indictment.
But on the facts of McDonald, it was perfectly reasonable given what happened at the door. And Justice Doherty deals with this with respect to adding a fact with respect to Mr. Snowbelin. This is the problem with the Crown electing too early or having an election and then the trier of fact finding facts that are different than the Crown goes into the trial believing. So I'm going to use the Snowbelin example and the McDonald example. So if Mr. McDonald was acquitted of everything but for the gun, he would be in a position where an absolute discharge would be perhaps entirely appropriate, a pure regulatory offense, thinking that what he was doing was perfectly innocent. So if he had been acquitted of all charges at trial, he would have been stuck with the 3-year mandatory minimum, and no one can dispute that it would have been perfectly reasonable. It was perfectly reasonable for the Crown to proceed by indictment. And then the trial judge is stuck with being forced to sentence this poor gentleman to 3 years in the penitentiary because he didn't understand that he couldn't bring the gun that he thought he was perfectly lawfully entitled to back to Nova Scotia. That has to be wrong, and that's the problem with leaving it all to Crown election, because the Crowns at the time they elect don't have the full knowledge, and after trials the facts change. The Crown elects thinking there's a number of things they can prove. And Justice Doherty deals with this in Newer, where he speaks of Mr. Snowbelin. The reason the gun came to the attention of the police is he was having a domestic dispute with his wife. Now, she didn't make any allegation of domestic abuse, but if she had, it would have been perfectly reasonable, in fact, expected, that the Crown would go by indictment. So then if Mr. Snowbelin is acquitted of the domestic abuse, the Crown has reasonably gone by indictment. He's in the same factual scenario as he was that got him an absolute discharge, but he had to go to trial to exonerate himself with respect to the domestic abuse. That's the problem with trusting the Crown with respect to the way to proceed. And going
at that point, the Crown can stay the proceedings against him, and seek to have a re-election to go summarily. It's not that the Crown is without remedy if they want to, because the alternative at that point is to have the law struck down as unconstitutional.
Well, I think McDonald, again, provides a useful example of it here. In that case, while he was not acquitted of everything, the Court of Appeal has struck down the law based on the reasonable hypothetical, but in a pretty compelling dissent, one of the justices feels that Mr. McDonald should, on the facts that he's been found guilty of, get 18 days time served. If this Court upholds the constitutionality of this law, it would seem that 3 years would be his fate, absent something that Justice Muldorfer, you're suggesting, staying it after a conviction or something of that, which would be a most unusual way to go about it. And again, that is putting all the faith in the Crown Attorney to do that. And Justice Doherty at the Court of Appeal certainly seemed to be persuaded by this counterfactual and I think for good reason, because that's certainly not a normal procedure to, after an individual is acquitted of some charges but convicted of one, to then stay the charge or do something like that after finding of guilt.
haven't left you a lot of time, but you do have almost 9 minutes.
All right. I can perhaps deal very briefly with the Section 7, and I just want to add one more thing with respect to Mr. McDonald, which shows that if you feel that the constitutionality of the 3-year mandatory minimum should fall, then it's clear that the 5-year mandatory minimum should fall as well. And I think Justice Cronk is very persuasive on this, that if the foundational offense of 3 years crumbles, so should the 5 years. It only makes good and common sense. And with respect to Mr. McDonald, for example, if he had another gun in Alberta and was prosecuted there, he could be facing 5 years. And one of the intents of this legislation, the Crown has asserted, is to prevent someone from bundling their offenses. So if someone wanted to bring them all in and accept liability, this legislation, because of Section 84, prevents them from doing it because the order does not matter. And that overrides the common law Koch principle and is, in my submission, somewhat problematic because you can be sentenced for your second firearm offense and receive the 5-year mandatory minimum, even though it's the first firearm you've ever had in your life. And that was clarified earlier, that you could have breached a weapons prohibition with, in my submission, a relatively innocuous weapon like a bracelet with spikes on it, which obviously is a prohibited weapon and should not be worn. But to say that you should get 5 years on your gun because of a violent piece of jewelry does not really seem to be logically connected. And that's why when you have escalating mandatory minimums, if they're for the same offense, it makes sense. But once you start throwing other predicate offenses into the mix, it becomes problematic. And that is, in essence, part of the foundation of the Section 7 argument, that in my submission, even if this Court finds that the law is cruel and unusual under Section 12, it would be useful to engage in the Section 7 analysis, particularly post-Bedford, where there's new clarity with respect to the doctrines of overbreadth and arbitrariness. Now, one of my friends said that Smith was really an arbitrariness case, but it was cruel and unusual because it arbitrarily affected so many people. So in my submission, that's sort of a similar analysis. What I'm talking about is offenses that would not meet the high threshold of gross disproportionality under Section 12, but are so arbitrary that they would be antithetical to our system of justice. And there's a chart in the factum that my submission highlights how this is possible. And given that you have different offenses that are tied together that create escalating mandatory minimums, this is the scenario that is found at paragraph 47. So, for example, and in the factum, it talks about an individual with a single bullet, but perhaps you could say an individual with a single spiked wristband. If they have that offense, so they are found with a restricted firearm, get bail, and then have this illegal wristband, you have two scenarios where the timing of the guilty plea dictates absolutely everything. So if the individual arrested on his breach of a 109 order decides to plead guilty so they won't pay, perhaps so they won't take away his bail on the firearms charge, you have scenario one, where the offender immediately pleads guilty to the prohibited weapon and receives 60 days. Perhaps duty counsel didn't inform them that now they have a predicate offense for a firearm and will have to receive 5 years for the firearm should the Crown proceed by indictment. Meanwhile, if the offender decides to somehow delay the 109 order case, waiving 11B all along to make sure by hook or crook, no matter what happens, it's heard second, you get a 3-year and 60-day sentence. That can't be right. This is the exact same individual, The punishment itself might not be so grossly disproportionate to offend the Charter, but there's something inherently wrong about a sentencing scheme that handcuffs the judge to sentence in this way. And in fact, there's a hypothetical in Smith by Justice Lemaire that somewhat highlights this. He indicates, what if there was a judge, for example, who gives a sentence that's completely in the range, but doesn't follow any sentencing provisions, just goes off his own and makes a sentence. If it fell in the range, even though it didn't follow any sentencing principle known to law, that still wouldn't be cruel and unusual because it falls in the range. But perhaps it could be arbitrary, particularly if it's the statute itself that forces irrational results, so that you have two like individuals completely identical, or in my example, the exact same person. But if you had two completely identical fact scenarios, and they're sitting down comparing their sentences, and there's a 2-year gap because of the order in which the sentences came before the court, that, by any definition, is arbitrary. And Section 12 doesn't seem to be the proper analytical tool to deal with this problem. And it's a unique problem that, in my submission, should be dealt with, because there are not many provisions of the code that have this sort of strange escalating of penalties where you have not particularly related offenses, one leading to a jump in the other. And Parliament might be given some guidance with respect to the wisdom of doing something like this, because in my submission it does not make very much sense for that. So if you're going, and part of the reason this has happened is obviously that the Koch principle has been overridden by the legislation as well, which is clearly permitted and may make sense in something like impaireds, where you have escalating sentences for the exact same offense. So the offense date doesn't matter, the conviction date does not matter. But in a case where the offenses are so different, then in my submission, the law should be struck down, not because it's necessarily cruel out of the range, it's just so arbitrary. And I think the example in the factum is, if you had a nominal fine for an offense, but the fine was $20 on Monday to Wednesday, but if you went to court Thursday to Friday, it was $100. That might not be cruel and unusual because it would be in the range, but there's something fundamentally wrong with that. It's so arbitrary, and Section 7 is the analysis for that. So in my submission, the law here should be looked at through a Section 7 analysis. But as the Court of Appeal correctly noted in my submission with Justice Cronk, if you find that the mandatory minimum with respect to the 3-year sentence for Noor is unconstitutional, it's virtually inevitable that you will find the same with respect to the 5 years for Mr. Charles. So, subject to any questions.
Thank you very much. The Court will rise for its lunch and recess. We'll be back, if that's all right, at 1:45. Thank you. Mr. Kapoor.
Good afternoon, Chief Justice, Justices. It's a pleasure to appear before you on behalf of the Advocate Society today. I would like to address questions 3 and 4 in the stated question by the Chief Justice, and namely the Section 7 question. And in this debate about Section 7, or mandatory minimums, there's a tendency to view this almost exclusively through the lens of gross disproportionality. But if you open the aperture just a little, what will come into focus are the erosions of serious Section 7 protections occasioned by the use of mandatory minimums. And this is more than just simply punishment. I'm talking about how a sentence is arrived at, and who gets to play in the determination of the sentence. The reality is that from a constitutional law perspective, or a broader Section 7 perspective, there's much more going on with mandatory minimum sentences than just simply whether or not the arrived mandatory minimum is grossly disproportionate. A mandatory minimum sentence, in my respectful submission, fundamentally alters the relationship between the governed and those who govern. It is the court that stands between Parliament and the citizenry to ensure that each one of us, are afforded a fair process by which a just sentence will be determined. Ultimately, this is an access to justice question. And I say that because access to justice isn't simply showing up in court and being told what your sentence will be. Access to justice is actually having an opportunity to say to the decision maker, here's what my sentence should be. This scheme, mandatory minimum schemes, deprive you, each one of us, of that opportunity to make those submissions, to participate in the process. The sentencing aspect of a criminal trial is very, very important. I mean, it is that point where liberty will be deprived. It is, and we know from the high number of guilty verdicts in our system or pleas, that much of the business of our criminal courts is sentencing. So to be able to say to the person who will decide, A, will you go to jail or not? B, if so, for how long? To be able to have some input there, in my respectful submission, is integral to our justice system. In other contexts, our court has not been shy to vindicate participatory rights. You've done it in security certificates. You've done it in a variety of administrative law issues in contexts. This should be no different. And this isn't to say that Parliament can't, by a properly structured law, if I can use the vernacular, put their thumb on the scale. We propose that there can be a presumptive sentence or a departure point from which judges, having entertained submissions, can either go up or go down. The beauty of that in our respectful submission is it allows you, each one of us, if we're in that position, to have an impact on the result, to make submissions on the very question of our liberty. And in this sense, whether we go to jail or not. And in this case, the key decision is made, as Justice Moldaver has remarked and others, by the prosecutor in the comfort of their office, in secret. The accused offender, eventual offender, has no impact on that decision-making. And it may be...
Why?
Sorry.
Why? Have a counsel like you that goes into the Crown, tells the Crown what your case is all about, recommends that the Crown asks the Crown to go summarily, and the Crown says, no, I'm going by way of indictment. You say, well, if you do, we'll bring a constitutional challenge. I don't quite understand that.
Let's take the second part of your example, which is the Crown says, no, I'm going to go ahead anyway. And I say, fine, you run the risk of the entire regime falling. The Section 12 litigation is not a proxy for a sentencing hearing. So the issue on Section 12 litigation is, at the first instance, on the individualized part of the test, is at once subjective, that is, take into account the individual's concerns. But it is also profoundly different because it says there will be a problem only if you can establish, you, the applicant, can establish that the mandatory minimum would be, sorry for the precise language, it's not shock the conscience, it's outrage decency. That's the language from Galt's. So as the applicant, you say, my appropriate sentence would be, let's say, 1.5 years, and the mandatory minimum is, let's say, 3 years. The question is, does that differential outrage decency?
Sorry,
and that's very different.
I want to just understand. Are you talking about the Section 7 in the context of the gap here, or are you talking about Section 7 as being demonstrating that all our jurisprudence so far, because I thought I heard you say we shouldn't have mandatory minimums, in which case I think we'd have to overrule a whole lot of authority from this court. But if you're talking about the gap, then that puts it in better perspective for me, at least.
Well, no, this is the gap. This is about the case where they proceed by way of indictment. That's what this is about. And so when you get in that circumstance and you litigate whether or not you're entitled to have what I call an individualized sentencing process, you need to establish that the operation of the mandatory minimum is in the first stage. It would outrage decency. And if you can't do that, then you do the reasonable hypothetical. And
isn't the problem that if you didn't have the gap, then the Crown could go summarily and the person could get a year and a half? I mean, are we challenging the 3 years, or are we challenging the gap? And your real position is there shouldn't be a gap because it leads to potential problems in terms of someone that deserves 18 months, but because they can't get 18 months, the Crown goes by way of indictment.
Well, yes, that as much. But also, though, I'm saying fundamentally, with mandatory minimums, when it's determined by the prosecutor to proceed by way of indictment, it removes the offender from making meaningful submissions before the trial judge. And it's one thing to say, Justice Moldaver, to say that let's go to the prosecutor and talk to the prosecutor, but the offender is entitled to have an independent, impartial tribunal decide. The prosecutor's not independent, impartial. You are. So in my respectful submission, the offender has the right to make submissions to the decision maker. The decision maker has to be independent and impartial. And those participatory rights, in my respectful submission, are eliminated by this regime. Now, there's been some suggestion about Malmo-Levine and how Malmo-Levine has said all of these problems with mandatory minimums are laundered through Section 12. Okay? But Malmo-Levine, paragraph 169 for your note, says more than that. In Malmo-Levine, this Court acknowledged that the proportionality principle of fundamental justice is not exhausted by the manifestation of Section 12. And the content of Section 7 is not limited to the sum of 8 to 14. So from an access to justice perspective, you want to be able to access your decision maker. That's not what Section 12 is about. Section 12 is about disproportionate impacts of mandatory minimums, not how you arrive at the sentence. And that's, in my respectful submission, what this Court should consider in evaluating this scheme and regime. And as was said by Justice LaBelle in Epili, in paragraph 38, judges enjoy a broad discretion in the sentencing process. The determination of a fit sentence is, subject to any specific statutory rules that have survived charter scrutiny, a highly individualized process. Sentencing judges must have sufficient maneuverability to tailor sentences to the circumstances of the particular offense and the particular offender. And this just does not do that. There's just no room for trial judges to do it. Nothing an offender can say. Thank you.
Mirza.
Thank you. If you'll let me for a moment, I'd like to take you back to where these cases began. Both of these cases came out of the urban centers in Toronto, like Jane and Finch, Scarborough, Malvern, Regent Park, these types of neighborhoods. Both of the accused before you are African Canadian. Mr. Smickle was also African Canadian. This may not be by coincidence. In Canada's most populated urban city, 62% of all persons prosecuted for this offense are African Canadian. That is a staggering number, I submit to you. 6 out of every 10 persons prosecuted for this offense and subject to the potential mandatory 3-year jail sentence are African Canadian. Justice Code acknowledged this in his trial ruling at paragraph 77. And to put this in perspective, African Canadians represent only 8% of the Toronto population and approximately 2% of the population in Canada at large. There is no doubt in my respectful submission that this law imposes a burden on African Canadians like no other group. It is the submission of the African Canadian Legal Clinic that reasonable members of our society and reasonable jurists would be shocked and their sense of decency would be offended by a sentencing provision that has such a desperate impact on one segment of the community. It's my respectful submission that this Court is in a position to anticipate the devastation that this law has and will continue to have on the African Canadian community. It is also a necessary contextual factor as per Morrissey. The advent of mandatory minimums of this specific nature contributes to a cycle of systemic discrimination that seems unbreakable. Many African Canadians become involved in this offense because of pre-existing socioeconomic disadvantage in living in those very neighborhoods I've identified. Once convicted, despite their circumstances that may otherwise reduce their jail sentence, judges must impose at least 3 years. While in jail, the record is clear that they suffer harsher conditions. And once returned to those same communities, they are far worse off. It is that same discrimination and disadvantage that this Court has recognized in cases about apprehension of bias and RDS, jury selection in Williams and Spence, police powers of investigative detention in Grant, strip searches in Golden, and most importantly, in other sentencing cases that don't involve mandatory minimums, such as Appealee. If this Court can consider the impact of anti-black racism and discrimination in those cases, it certainly can do so in the context of assessing mandatory minimums, where the correlation is clear. Only trusted sentencing judges with discretion have the ability to factor the distinct African Canadian experience into the sentencing analysis. This authority has to be restored. If it is not, the disproportionate impact of this 3-year mandatory jail sentence will take the current levels of incarceration of African Canadians to never-seen-before heights. It is a turbocharger to accelerate the black prison admission rate. That should give this Court reason to pause. The current over-incarceration of African Canadians is already at its highest levels. The numbers of blacks in jails have been increasing every year, growing by over 90% in the past decade. As I've identified to you, in jail, the discrimination does not end. The correctional investigator in 2012 identified that blacks are serving harsher sentences, are more prone to higher levels of categorization as maximum security issues, and they're also being released later. This was the same findings of the report of the Commission on Systemic Racism over 20 years ago. The ATLC submits that reasonable, informed members of Canadian society would find that to be intolerable. The American experience with mandatory minimums having a far greater effect on the black population while being ineffective in deterring crime has rightly caused the American community and the American society's sense of decency to be offended and to move away from those provisions. In my respectful submission, it is very important that Canada not make those same mistakes. Another reason that the African Canadian community would be disturbed by the sentencing law and the greater Canadian community at large is that it prohibits sentencing judges from accounting for that very experience of disadvantage and determining a fit sentence. If there is a clear link between the two, nothing should stand in that way. Of the 62% of African Canadians that are prosecuted for this offense in the Toronto courts, in my respectful submission, not all of them are deserving of 3 years in jail. Mr. Durstein persuasively took you through a scenario, and I'm going to do the same, of fundamental facts, fundamental categories, consistent with numerous gun cases in the Toronto courts originating from the urban areas. The accused is a young black male between 18 to 20 years old. He grows up and lives in a poorer neighborhood like Jane and Finch or Malvern. Unlike many of us, this makes him more prone to exposure to access to guns. And even though he's not engaged in any other criminal behavior, he becomes more exposed to the possibility of being in social interactions with other individuals that may possess guns. By virtue of these social interactions, he is put in a position where he's with peers and one of them decides to bring a loaded firearm. He does not object, he remains, he makes that mistake like many young people do, and pursuant to a police investigation, he's charged with this offense and convicted. My respectful submission, this is not a hypothetical that stands in the outliers. This is what the courts confront on a consistent basis in Toronto. What you have is individuals that you'll have 2 or 3 in a vehicle or in a home, differently situated. The Crown's position, well, one of them is the principal, the others were along for the ride. Certainly, even in that circumstance, by the time the trial plays out and the factors are put before the court, that even prosecutors would come to the conclusion that at least one of those individuals is not deserving of a 3-year jail sentence. But by virtue of already proceeding by indictment and the trial I've already proceeded with, and those facts coming to light at the conclusion of the trial, the trial Crown does not have the discretion to take a step back. If their position is this person is only deserving of 1 year in jail, certainly the result would be grossly disproportionate. In conclusion, this law cannot be analyzed responsibly without accounting for the African-Canadian experience. It would be repeating the American experience if our legal system were to stand by and watch the devastating effects in its rearview mirror for the next 10 or 20 years before reconsidering whether sentencing discretion had to be restored. Mr. Durstein took you to the notion that there are other African Canadians that, by virtue of being in the urban environment, are going to be put in a situation where they are less morally blameworthy than the gun-toting drug dealer or the gun-toting individual that is engaged in other criminality, but by virtue of those social interactions may very well be subject to the 3-year mandatory minimum sentence. Recently, this court said in appealee speaking through Justice LaBelle, just sanctions are those that do not operate in a discriminatory manner. In my respectful submission to you, that is a universal declaration of human rights, and it is time to end this injustice and restore discretion to the sentencing judges. Thank you.
Thank you. Mr. Hussein.
Thank you, Chief Justice, Justices. Before I turn to my primary submission, I'd like to try to answer some of the questions that were posed earlier in the day. The Chief Justice, Justice LaBelle and Justice Abella, asked questions about the subsidiary or additional role that Section 7 may have to play in addition to Section 12 in this analysis. And I think Mr. Kapoor ably dealt with that issue. But I do want to commend one additional case to you that speaks to that question. It's a very recently decided case from the Ontario Court of Appeal, the case of Safarzadeh Markali. It's at tab 23 of our Book of Authorities. It's a decision by Justice Strathy. At paragraph 22, Justice Strathy said, the principle of proportionality under Section 7, governs the sentencing process, whereas the standard of gross disproportionality governs the sentencing result. And I think that is a helpful starting place when we start to conceive of the respective roles of Section 7 and Section 12. And I will remind you, as Mr. Kapoor already did, that the Court has never ruled out a subsidiary or additional role for Section 7, even when another charter right, Sections 8 through 14, is implicated. The right to silence, the presumption of innocence, the right to reasonable bail, right against self-incrimination are all examples where Section 7 is helped to fill in the penumbra created by these other rights. With respect to reasonable hypotheticals and their continued value to our jurisprudence, I hadn't planned on saying anything about it because I think it has been covered quite exhaustively. But I will say this. I wonder if part of the confusion, perhaps, stems from the term. A reasonable hypothetical is perhaps a misleading term, because what you're doing in a reasonable hypothetical analysis is really no different than what you're doing in constitutional adjudication under Section 7, under Section 2A, or Section 2B of the Charter. What you're doing when you're assessing a law for constitutionality, you are considering the scope and the reach of that law, and then you're trying to conceive of reasonable circumstances in which that law might capture those scenarios. And that necessarily implicates a reasonable hypothetical type of analysis when it comes to sentencing. And one additional, very quickly, reason why we should think very, very carefully about doing away with the reasonable hypothetical analysis, and that's a point about access to justice. Under the Crown's position, the Crown's position is you need to wait for the perfect case to come before the courts. That's essentially what it amounts to if you're doing away with the reasonable hypothetical. But there are practical constraints. The perfect case might never come before the courts, or maybe the perfect case has come before the courts, but that accused didn't have the wherewithal or the resources or the intrepid counsel to mount an effective constitutional challenge. We should be very wary of reversing 30 years of constitutional jurisprudence if the effect in particular is to create additional barriers for indigent accused to access their constitutional rights. I think the issue of Crown discretion has been more than adequately dealt with by my colleagues, but I wanted to deal very quickly with a point raised by my friend for the Alberta Attorney General, who tried to draw a distinction between Crown discretion of whether to apply the law as opposed to Crown discretion that's embedded in the law. I would point out that in this Court's decision in Bain that dealt with the Crown's additional peremptory challenges in the context of jury selection, that was a case in which the Crown discretion was embedded into the statute. And in that case, at paragraph 8, this Court wrote, "Unfortunately, it would seem that whenever the Crown is granted a statutory power, that power can be used abusively on occasion. The protection of basic rights should not depend on the reliance in the continuous exemplary conduct of the Crown." And that would apply equally here. Now, I know, Justice Moldaver, and I'm going to be paraphrasing your line of questioning all day, but you seem to be saying, put aside that highbrow rhetoric and show me a case in which Crown discretion has been used improperly in these types of cases. I think Mr. Durstein and counsel for Mr. Charles adequately pointed out some cases in the case law in which, in the end, it turned out that Crown discretion, Crown election, was exercised probably incorrectly in hindsight. But more than that, it's not just whether Crown discretion or election has been exercised improperly, but the question should also be, is there a significant risk in the error in the Crown election? And the reason there is, in this particular context, a significant risk is because at the time of the Crown election, so little is known about the facts of the case. There are very few incontrovertible facts known at the time that the election is made. The specific circumstances of the offense are rarely known. The mitigating background factors are rarely known. The incontrovertible facts that are known are things like neighborhood where it took place, the age of the accused, the race of the accused, not facts that are going to enable the Crown to make a responsible election. Now, Justice Cromwell asked a question about what goes into weighing proportionality. And that was really what our submissions were meant to focus on here. And I see I only have 3 minutes here, so I'll attempt to sketch it out and rest on our written submissions. Identifying the proportionate sentence for the individual offender is a crucial part in any Section 12 analysis, because you can't meaningfully compare the otherwise proportionate sentence against the mandatory minimum to determine a Section 12 breach unless you've first been able to identify the proportionate sentence for that particular offender in the absence of a mandatory minimum. And our respectful submission has been that this is where one place in which the courts could have been doing better in translating the principles that this Court has laid down about proportionality into a usable framework. And part of the problem is a conceptual one. The difficulty stems from the fact that although the proportionality principle is the fundamental principle of sentencing, there are all kinds of other principles, purposes, sentencing objectives that tug in all manner of direction. And we don't really yet have a very effective way of reconciling these competing principles. And so in our factum, what we set out to attempt to do was to address this problem by setting out a test to reconcile and balance these competing principles. And the three-part test that we lay out is at page 5, paragraph 16 of our factum. We ask what sentence is rationally connected to the applicable sentencing objectives in Section 718 of the Code. What sentence is no more severe than necessary to accomplish the applicable sentencing objectives? And thirdly, what sentence achieves the proper balance between the effect of the punishment on the individual and society's interest in accomplishing and effecting that sentence? Now, you'll see we're drawing on the Oakes lexicon of rational connection, minimal impairment, and balancing of effects. Those ideas are, of course, basic measures of proportionality, and the appeal of a test like Oakes is it provides an intelligible, easy-to-apply way of balancing rights against utilitarian interests. And although with sentencing you're not balancing rights against the legislative objective, you are balancing this retributivist notion that an individual should be punished according to his or her moral blameworthiness against societal objectives like those listed in Section 718 of the Criminal Code, like protection of society, like denunciation, like deterrence. And so the benefit of, in our respectful submission, the benefit of our proposed test is that we're proposing a way to balance these principles in an easy-to-apply way. And once you get that proportionate sentence for the individual offender before the courts or for the hypothetical offender, you then have an objective and helpful baseline against which to assess the mandatory minimum to determine whether for the reasonable hypothetical offender or the offender before the courts there is a gap that renders that punishment grossly disproportionate.
Mr. Hussein, I have to ask you a question. Your time's almost up. But if you look at Justice Doherty's reasonable hypothetical, the question relates to Crown discretion, and it's got to be made quickly and so on. I'd like you to point out in Justice Doherty's example what it is that the Crown wouldn't know within a matter of days, number one. And number two, is it not true that if new information comes to the attention of the Crown, if the Crown has elected to go by way of indictment, the Crown has at least 6 months, within which to change that election, and even after 6 months, with the consent of the accused, the Crown can change that election.
Yeah.
So can you sort of suggested that this is really perilous because the Crowns won't know and so on. And with respect, I just have trouble with that.
I know that my time is up, but I would love to answer Justice Moldaver's question. First of all, I'm not hanging my hat entirely on Justice Doherty's reasonable hypothetical. But let's change that hypothetical slightly. Let's make that person slightly more blameworthy, but then make him someone who wasn't a landed immigrant or wasn't a citizen of Canada and who could be deportable. That might not necessarily be a fact that would be known at the outset when the Crown made their election. And indeed, in FAM, that was the crucial mistake that was made. The immigration status of the individual wasn't known. And Justice Moldaver, in relying on Crown discretion so heavily, I understand you're saying that if the Crown makes a mistake they can reverse themselves later on when they know facts. But it looks like here you're relying on the Crown to make the right election in the first instance. And then you're saying, okay, if they don't make the right election, let's rely on the Crown to revise their position when new facts come to light. And if they fail to correct their position, then rely on the Crown discretion and good faith to enter a stay at the end of the proceedings. But that's starting to sound awfully like a society ruled by man or woman rather than a society ruled by law. It's putting far too much faith in Crown discretion. It's exactly the type of thing that this Court has eschewed in the most strong terms since Bain. Thank you.
Thank you. Mr. Guattardi.
Chief Justice, Justices, it's my privilege to appear before you on behalf of the Canadian Bar Association today. Professor Michael Chonry accurately labels mandatory minimum sentences as representing the greatest gap between knowledge and policy. While the great divide between evidence and legislation may be constitutionally insignificant in some arenas, in my submission, the deprivation of liberty is not one of them. Whether or not we are warehousing offenders under minimum sentences without regard to any rational principle is properly subject to the most detailed constitutional scrutiny. The essence of the problem in my submission is what to do with the significantly mitigated case. Much of what you've heard today essentially comes down to one issue: what to do with the possibly infrequent but very real case where applications of the minimum would constitute a clear injustice. The perfect constitutional storm, as it's been called, is a convergence of three critical circumstances. Factor one, the state's decision to not only exponentially increase the number of minimum sentences, but to apply them to many offenses with very broad terms. Regardless of the debate of the precise scope of Section 95(2), it clearly applies to a broad number of circumstances. Like many of our growing list of minimum offenses, it's not targeted to highly aggravated circumstances, such as the use of a firearm in the commission of another crime, or the use of a firearm which creates a risk of bodily harm. The second factor is this Court's decision in Ferguson that constitutional exemptions are not the proper vehicle to deal with the exceptional case. And the third factor is the continued recognition by this Court and other courts that certain circumstances of offenders may constitute highly mitigating circumstances, including an Aboriginal offender who has been subject to systemic discrimination and persons whose mental illness, short of NCRMD, was causative of the offense. The debate about the proper Section 12 framework, including the complex and sometimes confusing reasonable hypothetical analysis, in our view, is driven by the fact that there's no adequate tool to deal with the problem of the significantly mitigated case. The CBA submits that there is a solution to this quagmire, which is used in a broad array of jurisdictions, and that's the legislative exemption provision. This is a clause which increases the severity of an offense by creating a strong presumption of a minimum sentence, but accords a limited discretion to a judge to not apply the minimum in truly appropriate circumstances. Now, I want to make clear this is not a submission about preferred policy. And in an attempt to answer the question of Justice Abella and some of the other justices here today, I say Section 12 does provide this Court with an appropriate analytical framework to assess the policy decisions of Parliament. The lack of an exemption clause is a highly relevant Section 12 factor, and we say this for the following four reasons. One of the core Section 12 criteria is whether there's a valid alternative to the punishment imposed. And we submit that a valid and reasonable alternative to imposing a mandatory sentence on an offender is to propose a presumptively mandatory sentence which will not be applied in the exceptional case. This same factor could be considered under Section 7 in the lexicon of overbreadth or arbitrariness. And you've heard some recent submissions on how Section 7 might be used as an analytical framework, and the CBA agrees with that as well. This Court has found in past cases, including the recent Trial Lawyers Association case, that the presence of an adequate exemption clause may be necessary for a statute to meet a constitutional minimum. And I say respectfully that when considering the subject matter of this case, liberty, a lack of judicial discretion to fashion a just sentence must be constitutionally relevant to that analysis. And I would just point out, in furtherance of some of the questions and comments made by the Chief Justice, we're not the only jurisdiction wrestling with this question. When you look around the world to many of the common law jurisdictions that employ MMP regimes, they've grappled with the same question, but they've come to the answer that the CBA proposes, and that's the legislative exemption as a relevant factor in analyzing whether a mandatory minimum penalty can pass constitutional muster. England, New Zealand, Australia, South Africa, even our friends to the south employ exemption regimes in their sentencing laws, and even the Americans now are reintroducing judicial discretion and have moved from a mandatory system to a presumptive system in their federal sentencing guidelines. Madam Justice Malloy in Smickle found that the absence of an exemption clause in Section 95(2) contributed to the section being overly broad. Exemption clauses can and have been targeted to truly appropriate circumstances. Their use and interpretation in numerous other jurisdictions indicates that they can be employed to increase the severity of an offense while preventing clear injustices. The CBA submits that an exemption clause, such as the presence of substantial and compelling circumstances, to borrow the language of South Africa, those types of mitigating circumstances would provide an appropriate balance between a strong presumption of application of the minimum and preventing clearly unjust sentences. And this would also preserve a modicum of the individualized sentencing process that is such a central piece of the Canadian sentencing regime.
This sounds like a speech that should be made to Parliament.
I've made that speech many times, Chief Justice.
We can't do anything about the absence of it here.
Well, in my submission, you can, Chief Justice. This isn't a question of me advocating for a different policy. The lack of an exemption clause, which we know from looking to the other jurisdictions around the world, it's not a hypothetical alternative. It's a reasonable, valid alternative. And that's one of the key parts of the test under Section 12. So we can look at these regimes and the objectives that they put in place and the objectives that Parliament put in place with the mandatory minimum sentences. And those valid objectives can be accomplished just as efficiently, more efficiently, with a presumptive regime that maintains a modicum of judicial discretion to deal with the factual outlier, to deal with a case where we've all seen it, we've heard cases discussed today, where the judge themselves is twisting, is uncomfortable in the sense that they have to impose. They know that it's unjust, but they have no choice. And in my submission, the fact that this option is there, Parliament's aware that it's there, and they choose to press ahead and enact these laws without having recourse, that's fine. That's their choice. But it needs to become a significant part of the Section 12 analysis to determine whether or not these laws can pass muster. I'd like to turn to the second issue that the CBA raises. It's tied to the first, but it relates to the problem of dealing with significant mitigating circumstances and the reasonable hypothetical. Justice Cromwell's asked some of the parties here whether or not personal circumstances should be part of the reasonable hypothetical. CBA says clearly that they should. If reasonable hypotheticals under Section 12 don't consider the circumstances of two vastly overrepresented and growing groups in our prison population of Aboriginal persons and persons with serious mental illness and incapacity. We have a serious constitutional problem in my submission. There's been a lot of debate about what constitutes the reasonable hypothetical or the reasonable offender. Well, we need look no further than our prisons. That will tell you who is going to jail in this country today. And it's Aboriginal people, and in a growing way, people with serious mental illness short of NCRMD. If our laws, under a reasonable hypothetical test, putting those basic, well-accepted factors in as part of the reasonable hypothetical, can't pass constitutional muster, they shouldn't. This Parliament is enacting laws for the criminal law and the criminal justice system as it exists today. They're well aware of the problems that we face in the system and the overrepresentation of these parties. And so in crafting the laws as they are today, they need to take that in mind. Otherwise, these laws cannot pass.
Thank you. Ms. Dennison, reply.
Yes, just very, very briefly. The first point I'd like to address is Mr. Dernstein's concern about the offense, Section 95, not being so blameworthy where there is no evidence of criminal intention with regards to use of the firearms. And with respect, Section 95 is structured that there is no requirement to prove criminal intent. And a good reason why that's the case is demonstrated by the cases of Noor, Smickle, and Charles. It'd be very difficult to prove what Mr. Noor intended to do with the firearm, for the same reason that the length of possession isn't a requirement of this offense. It'd be almost impossible in most instances for the Crown to determine or prove how long the person has possessed the firearm. He then went on and discussed the case of Morrison as being a case of the hairdresser, being less serious. However, she didn't challenge the constitutionality of the act, and it was a guilty plea, but there are several aggravating factors in this case that I'd like to draw to the Court's attention. First, it was a prohibited weapon. The firearm was initially stolen. The serial number was defaced from it. Even if you accept her version of events of how she came into possess the firearm, which is she took it from a friend who was having suicidal thoughts who later killed himself, she still kept it for almost, I believe, 9 months after and moved it from Waterloo to Toronto. In doing so, a quick calculation, she committed at least 3 or 4 separate criminal code offenses. She wasn't licensed. She wasn't authorized to have it at either location in Waterloo or Toronto. She wasn't authorized to transport it, and she didn't store it properly because it was with ammunition. We submit that that in itself is dangerous criminal conduct. In the second point, in response to Justice Moldaver's question that isn't the difference is there a difference between the constitutionality of the law and the manner in which it's executed by Crowns? Indeed, that is an approach that this Court has consistently applied in such cases as Little Sisters, Eldridge, Kwajalein, and most recently in the case of Conception, which leads me to Anderson, which this Court recently considered, which talks about the importance of the exercise of Crown discretion to our criminal justice system. Now, my friend the Advocate Society talked about this right to participate in the process. An accused person has never had the right to participate in the process, nor is it a principle of fundamental justice, to determine if the Crown is going to proceed summarily or by way of indictment. And those decisions often trigger different consequences, just as proceeding with a certain charge over another charge may subject someone to a different sentence. So with respect, we disagree with his submission concerning that Section 7 right. And finally, we heard a lot of comments with regards to the effectiveness of MMPs generally and in relation to this one. I just want to make it clear that the position of the Attorney General is that the penological goals are and can be considered under the Section 12 analysis. But with regards to their effectiveness, that is a Section 1 issue. And I'd like to draw your attention to a couple of points. First, with regards to deterrence, I'd like to draw you to the respondent's records, and just for your reference, at page 48, the evidence of David Abrams, and pages 101, 106, and 112 of Thomas Gabor, would talk about the fact that while there's been some recognition with regards to the effectiveness of mandatory minimums in the three-strike context, there is some evidence that deterrence works with relation to mandatory minimums in firearm offenses. And secondly, this offense isn't just concerned about deterrence. It's concerned about denunciation and incapacitation, which is particularly important with regards to the 5-year MMP. And tab 17 of our condensed book demonstrates that when these individuals are arrested and taken off the street and incapacitated, that there's often a drop in crime, which legitimizes Parliament's decision to utilize MMPs in the context of these offenses. Thank you.
Ms. Biasso?
Very briefly, I wanted to clarify a point that arose in the respondent's submissions. To be clear, both the cases of Smickle and McDonald were situations of real danger posed by the firearm, and the courts of appeal in both cases found that the 3-year mandatory minimum sentence in those cases was constitutional. Further, I would submit it as a wrong-headed approach to then posit a counterfactual from those facts and say, what if there had been no danger? What if these offenders had been somehow morally innocent? This is not what this court did in Ferguson. If you recall, in Ferguson, the trial judge had made some findings on sentencing that significantly reduced the offender's moral culpability. This court corrected those findings as being inconsistent with the jury's verdict. On the basis of the corrected findings, this court found that a 4-year mandatory minimum sentence was constitutional. Significantly, this court did not then turn around to posit a hypothetical saying, well, what if the trial judge had been right? What if Mr. Ferguson was indeed virtually innocent? What if he had only acted involuntarily? And yet, in my submission, this is what the respondents are inviting you to do. In my respectful submission, such counterfactuals that are, by definition, contrary to proven fact are not a proper basis on which to decide the constitutionality of the statutory
But aren't
provision.
they hypotheticals?
In my submission, they are not. There should not be valid hypotheticals.
Why not? They could happen. I thought it's the same kind of argument as you were making. This could happen. Didn't happen, but it could.
But Chief Justice, my position was that we should look at the cases as they actually happened, whereas I see this as a fundamentally different approach because it is by definition saying it is not what actually happened. We know the facts as found, the proper facts found, and yet for some reason we go further and actually assume the contrary. I would submit to the extent that we do that and deliberately step outside the boundaries of facts before the courts, that it is not a proper basis at that point. The hypothetical ceases to be reasonable on any view of the matter. Thank you.
The court stands adjourned.